Welcome back and thank you for staying with All Angles. Now, the Senzo murder trial has been delayed because the state's next witness has objected to proceedings being recorded live. However, she has no objection to journalists remaining in court and reporting on her testimony, as well as being taken pictures or being spoken to outside of court. Now, 5 men are currently on trial for the murder of the soccer star who was shot and killed on the 26th of October in 2014 in Vosloorus in Gauteng. Now, I am joined by legal analyst Zola Majavu to just tell us what he thinks in terms of the applications that have been made today. Mr. Majavu, thank you so much for your time. Just firstly, does she have any base, especially with the state saying that she only let them know last night about this objection?
Good afternoon, Masego, and good afternoon to the viewers out there. Firstly, it is not open to her to decide the conditions under which she will testify. The fact of the matter is she remains a compellable witness. So if she decides, if her conditions are not met, that she's not going to testify, she can be compelled to testify, and there's nothing she can do about it. She will have to comply with the court order. Secondly, remember that as we speak, all the defense counsel are already in possession of her statement, if it's a she. So it is of no moment for her to say, I can only comply through audio recording. The fact that our open justice in society requires that is also buttressed by the right of the media for freedom of expression. And she also belatedly informed the state last night. Who does that? The court's processes do not work on the basis of our individual whims. In any event, these proceedings have been televised live. The court can give certain conditions, for example, to say her face may not necessarily be beamed, but the coverage can be live. There's absolutely nothing wrong with that. Other witnesses have testified on that basis, so I cannot imagine that her request or her conditions have any merit. And I'd be surprised if the judge were to allow that. But we have to respect the fact that the judge is yet to make a decision.
All right. There's a bite that I'm going to ask the team to play, but before I ask the team to show you a snippet of that bite, because I know you also have your own cases that you're following and you didn't really see what happened in court today. The state then saying to the judge in response to his question on whether or not what would happen rather if he decides that she must testify in open court. The state's response being that she told them that she'd have no choice but to stand down. Is that even enough for the state to say that? It's their case. Shouldn't they use their power to subpoena a crucial witness?
Of course, you're absolutely spot on. You don't have to be a lawyer to know that whoever is to testify, especially as part of the defense, the state's witness, is compellable. If she does not want to testify, well, it means that her testimony would obviously deprive the state of its ability to prove its case, and the onus rests on the state and not on the defense. So it's a call that the state will have to make. If they feel that their own witness is now not cooperating with them, there are processes in court that will enable that particular person to testify, especially in the interest of justice. As a prosecutor, your job is not only to secure a conviction, but if you have information that may tend to exculpate or exonerate an accused person, you are duty-bound to do so. So I cannot imagine that this particular witness, whoever she is in a position to tell the court the conditions under which she can testify. She will be forced to testify, but the risk is that she may recant and not assist or advance the state's case any further, which will be to the benefit of the defense.
All right, let's get the team to play a snippet of what one of the defense lawyers said in terms of her argument that she would be, or rather her safety would be in danger if she testifies publicly. Let's just have a listen.
The issue of personal safety has been raised, my lord, by the state. So I'm saying, my lord, if we were to consider the personal safety of this witness in isolation, what about the personal safety of other people? I myself, as the defense counsel for accused number 5, had been posted on Instagram and all social medias by the same witness, my lord. My safety also as well has been compromised, but I'm proceeding with the trial. The pressure as well, my lord, that has been stated as another reason that broadcasting will put pressure on her. What kind of pressure, my lord? It has not been placed before this court. How? The nature of extent of the pressure, the prejudice. In what way, in what sense will pressure? Because, my lord, this is a person of a public figure. This is a person who is known by everyone. This is a person, my lord, who has been posting herself on her pages of social media about this case. And then if today he's saying that he will encounter pressure or suffer pressure, in what way? That had to be placed before this court.
I don't know what you think, Mr. Majavu, but I seem to agree with the defense lawyer. This is a person who, for instance, has taken to social media to talk about this case. This person has spoken to our senior reporter, Zola Majavu, about this particular case while the trial is on. What do you think about Shololo's arguments? Do you also agree?
She's spot on. I couldn't have said it better. Everyone who participates in a trial of this nature is under some sort of pressure. I am myself under pressure for the commentary that I give. Some people may or may not like my take on the matter, but it is the nature of the beast. The judge is himself under pressure. Everybody is beamed and televised on TV, but that ought not to stand in the way of open justice and the rule of law. Remember, broadcasting rights of the media has become settled law in terms of the SCA judgments. It is the rule as opposed to the exception. So it is incumbent upon the person who is otherwise not prepared to testify in a manner determined by the court to say what is the prejudice, so that the nature of the prejudice can be counterbalanced against other competing rights. So you can't just be told that there's going to be pressure. Of course, the nature of the pressure must translate into some prejudice which may not be found to be in accordance with the rule of law or the operations of natural justice. And remember, there are people whose lives are on the line here. In the event of a conviction, these guys will go away for a long period of time. So you can't compromise their rights at the altar of the convenience of a state witness. He or she must make up their minds. Are they going to stick to the statement to which they've deposed? If so, they must be subjected to cross-examination by all the defense counsel in respect of the accused person. So it simply is not open a witness to call the shots in the manner in which we are told this particular person wants to. And the public nature of that particular person also militates against any form of perceived pressure. If you post yourself on social media, you are putting yourself out there, and social media is ruthless. You invited the pressure because you opened the door. And in any event, the courts are supposed to be open to the public. Court space is limited. So the televisation or the otherwise beaming of these proceedings is an overflow, if I may use the term. Those who cannot be physically in court must be able to follow the proceedings. The accused persons have got families who have a direct interest in following these proceedings. Now, if a witness decides, no, for whatever reasons of pressure that is undefined and not properly ventilated before the presiding judge, that she is going to have to reconsider her position. Justice and the rule of law does not work that way. I can guarantee you she will be compelled to testify. If she does not want to testify, then Advocate Baloyi will have to move on without her testimony. And if it is an important will in the evidential cock that the state needs, and she cannot be led, tough luck for the state. It means the defense will then use that to its own benefit. So in all likelihood, if you ask me, I think the judge is going to see through this. The judge may say, if you are worried about your face being directly beamed, for example, the judge may direct that one camera angle should be positioned in such a manner that doesn't physically show her face. But to put a total embargo on the audio-visual televisation of these proceedings, I think it's a big ask, and I don't see how a judge will permit that.
I think for me, what also goes against it is that in their application, the state says that she doesn't even mind being taken a picture of or visuals of outside of court, whether in the corridors or outside of the actual building. She doesn't mind that. It's just when she's in the witness stand, she expects that not to happen. But in the same breath, says that we can actually post later on our social platforms as media her entire testimony. So that also just confused me. But tell me something about what you think, Mr. Majavu, about the state, saying that this is something that they were only let known by this particular witness yesterday. Are they not supposed to advise their witness that this would possibly not be possible? The lawyers for the defense are saying that this is something that was supposed to be dealt with in the beginning, because the fourth estate, the media, was allowed to to record proceedings from the beginning. So to bring this case to the judge now and expect people to argue against your heads of argument at the last minute, isn't that unfair?
Not only is it unfair, it is silly with respect, because remember, there are other stakeholders in this judicial continuum, and it's court time that is now being squandered. It's not like she didn't know that she was going to have to testify at some point. The fact that it happens to be today does not automatically give rise to this latter-day concerns about pressure and safety. It is simply not correct, because all other parties have a right to respond to that type of application, even if it is on an informal basis. So to spring it up last night, it means she's also not respecting the state. She's not respecting Advocate Baloyi, because Advocate Baloyi has a job to do. He has evidence to lead, and the nature of the evidence is already before all defense counsel. The only person who doesn't know what that witness is going to say is the presiding judge.
Well, thank you so much for speaking to us, Mr. Majavu, and for availing yourself. Legal analyst Zola Majavu speaking to us there about what's been happening in the Senzo murder trial. Nothing really, with the state saying that its next witness is asking not to be recorded. As you heard from Moloko earlier, that judgment will be handed down on Wednesday, but at 2 o'clock we expect that the defense, or rather the lawyers for the media, including our own here at eMedia, will argue their points on why the media should stay in court.